taking all the punishment from Chauvin, no one else. So I think this is the right decision, but let's bring back in our think tank. Neama Rahmani, I want to start with you. Can you now calm everyone down at home about what happened in the total picture of the judge's decision today, because this is just one of the charges?
Yes, it is, Vinny, and you are right. It is the right decision here. Now, Minnesota is one of the few states that has third-degree murder, and that's that sort of depraved heart murder that you learn about in law school. And the classic example is, you shoot into an empty apartment, or an occupied apartment. What happened with Breonna Taylor? But that's, we won't go there. In this particular state, Minnesota, though, the depraved heart action has to affect someone else. So because Floyd was the one who was killed, and the assault and the felony murder that resulted therefrom caused his death, it's not an appropriate case for third-degree murder under Minnesota case law, right? But all the other charges remain. The felony murder remains. The assault charges remain. The aiding and abetting the assault that caused the felony murder, everything remains. So the more serious charges are there. The Attorney General out there has done a great job. 8 of the 9 counts were preserved. So this is really much ado about nothing. And the judge did get it right. And one of the better opinions I've read in a long time.
Yeah, when the opinion came down, I said, I hope the judge explains it. And then I saw it's like 107 pages, and I was like, oh, yeah, he's going to explain it. Dewitt, today, if we look at today as a war, and third-degree murder is a battle, so the defense won the battle, but they really lost the war today.
I think that's right. As was said by Neama, look, 8 of the 9 charges still remain, and the more severe ones still remain. The second-degree murder is still there on the record, and I think there is a good shot at the prosecution of successfully prosecuting the second-degree murder charge. The aiding and abetting charges are also there. Under Minnesota statute, the third-degree murder charge just doesn't seem to stick. There's not enough there to suggest that other people were in danger. Certainly, there's nothing that would suggest that them kneeling on George Floyd's neck would also endanger the onlookers or folks in the general vicinity. So I think they got it right, but it's a small and short-lived victory because now the real work starts, because now they have to defend the fact that this officer knew what he was doing was very dangerous to George Floyd, understood the risk to his life. You heard in the little recording a little bit before that one of the officers was telling Chauvin, hey, look, I'm a little concerned about the excited delirium. Of course, that is something that is often used as a justification for wrongful death actions in many civil rights litigation across the country. So I think it's a short-lived victory. The war is still on, and I think the prosecution is sitting in a really good place.
Lara, are you surprised that all the aiding and abetting charges survived?
No, I'm not surprised at all. I can't see the judge throwing these out, but I have to say something addressing what Neama stated earlier, or you stated. I don't see this as a victory, honestly. The fact that the third-degree murder was thrown out, I don't see that as a victory for the defense. Remember, as defense counsel, sometimes we want some of these lesser charges included in the complaint because we're hoping that the jury gets to pick, has a choice. Instead of going to the worst case scenario, maybe they'll do a compromise type verdict and go to one of the lesser charges. So it's not necessarily a verdict. I don't see that as a verdict. And am I surprised that the aiding and abetting charges are still there? Not at all. I would have been surprised if they were thrown out.
All right, Neama.
Well, the reason I thought it was a victory, is because the defense really tried to knock out those aiding and abetting charges for the officers, right? They really tried to, argue that the substantial cause was drugs that caused Floyd's death. So there were some pretty serious arguments that could have knocked the case out, and the judge overruled all those arguments, right? And says this is a question for the jury. I'm not going to step in as the judge and determine what the substantial factor was, whether drugs were involved or whether, these officers did enough to aid and abet the felony murder, or whether Chauvin was acting according to police protocol. So all the big defenses that the defense raised, they were all dismissed and overruled today.
Dewitt, how are prosecutors going to get the jury inside the minds of these officers? And let's get away from Chauvin for a moment. How about the aiding and abettors? Because they're facing as much time as he is. How are they going to get into their minds to prove to this jury that, number one, they knew Chauvin was trying to commit a crime, and they wanted to intentionally make sure he was able to commit that crime? And the crime, I guess, is the assault, because it's kind of like a felony murder case. How are they going to take the jury inside the minds of those other three officers?
Great question. I think the one way you could do that is to go to their training and talk about the training that these officers have. And you could do that through a police practices expert or one of the more senior members of that particular police department in the training that they had about proper restraint and or excited delirium. I believe that was Lane who was making a statement to Chauvin about his concern over excited delirium and whether or not that was something that was a worthwhile consideration for picking George Floyd up off of the ground. I think once you delve into the training that these officers have, then you get to understand what they're thinking. Some of it, of course, is revealed in the audio and the video, but the training, I think, is really going to play a big part and role in the jury's mind about what these officers were thinking and or what they should have been thinking while they lay there for over 8 minutes with George Floyd underneath them.
Lara, I know what the defendants are going to say. They're going to say, listen, we were restraining him until the EMTs arrived. I mean, our whole purpose of staying on top of him was to restrain him and keep him there until EMT was able to come. So how are prosecutors going to go from that and get this jury to believe that, no, they weren't restraining him until the EMTs got there. They wanted to restrain him to make sure that Chauvin could assault him?
Well, I think it's pretty obvious at this point where someone is pleading, begging to be let go of because he can't breathe, I can't breathe, I can't breathe. I mean, they're going to have trouble. They're going to have trouble saying that, we're just restraining him. This is no longer about restraint. Someone who's dying in your hands, someone who can't breathe anymore. Why are we even restraining him? It's the exact opposite. You want to make sure you can do everything possible, whether it be as an officer or a human being, to help him breathe so he doesn't die. So this idea that they were only helping him restrain George Floyd, it's just...
So you think they wanted to hurt him? All four officers wanted to hurt him. That was their intent.
I mean, that's the only...
That's what you got to prove.
How else can you say that? Yeah, I mean, at this point, you have to say that if they didn't want to hurt him, then they would have had to...
No, you have to prove that they wanted to hurt him. So...
I understand that they are. They're helping another officer hurt him. That's exactly what they're doing. They're helping another officer keep him down while he's saying he cannot breathe. So that's exactly what they're doing.
No, keeping him down is different than hurting him. I mean, it's got to be... Neema,
I disagree with you on that. Keeping him down.
Neema, finish it up for me here. Neema,
Yeah,
how are you going to prove it that they want to make sure Chauvin can assault him? Because that's what the legal requirement is in Minnesota. It's tough.
That is a legal requirement, but it's much easier to prove that Lane and Tal wanted to hurt Floyd than that they wanted to murder him. So the felony murder charges are much easier for the AG's office to prove. That's why it's charged the way it is. Yeah, is it a difficult argument? No question, but it's much easier than proving that they intended to murder or cause significant bodily harm to Floyd.
All right, folks, got a lot more to cover. When we come back, we're going to go on the dot.